Good afternoon, all. On behalf of IoT Academy, we welcome you all for the first session of National Level Faculty Development Program on IPR, Entrepreneurship and Startups. Let me introduce the resource person of today's session, Dr. Bhupal Bhattacharya. Dr. Bhupal Bhattacharya is presently working as an assistant professor and head with Department of Law, Raiganj University, West Bengal. He has around 12 years of academic experience and 3 years of industrial and court experience. His academic qualifications include BCom, Master of Legislative Laws, Master of Social Work, and PhD in Law. He is in the editorial board of many national and international journals. Dr. Bhupal has to his credit 4 books and has also published an authored book on the concept of direct and indirect taxes. His many research papers are published in various Scopus Index international journals. He is the recipient of Protection of Nature and Environment Award for his research contribution by the Global Education and Corporate Leadership 2020. He has chaired many national and international conferences, seminars, FTPs, and was also invited as a keynote speaker in many events. We welcome you, sir. And with this, we hand over the session to Dr. Bhupal Bhattacharya.
Thank you so much, ma'am, for giving such a generous introduction about me. Very good afternoon, everyone, all the participants, the organizing team of the IoT Academy, the director, Ms. Jayalakshmi Rajarajan of IoT Academy. So I'm very much privileged and honored for getting this opportunity to for getting the invitation from IoT Academy to share on this topic, that's for the basics of IPR. Covering the basic concepts of IPR along with some of the legal remedies. Say, for example, all of a sudden, if your IPR rights is getting violated, in that case, how you can go for what kind of remedy you can seek from the court of law. So, with this, I'm going to start.
Excuse me, sir.
Yeah, ma'am, please move to the next slide.
Sir, your voice is breaking, sir.
Is this okay now?
Hello? It is okay now, sir. Yes, sir,
Okay,
yes, sir, it is okay now. But at times it is breaking, sir. Thank you, sir.
Sorry. Anyway, so very good afternoon, everyone, all the participants who are present over here. Getting the invitation from me to present my view on the IPR and some of the for my views on. So that is about the IPR. Why? We all know that in these present days, IPR is a very new concept, Earlier, that concept was not there. But in these days, Government of India is giving very much priority on this concept. That yes, we need to go for registering something. That yes, if we are inventing something, if we are discovering something, if something is new, if something is coming from our mind, that must be protected. So since in these days we have made a very in this global area, the products of India gets exported to different countries, to other countries, foreign countries. Equally, for the products of foreign countries also get imported within the territory of India. Now the concept is, now the question is, if we find some product from foreign country and if we put a label on that product, say for example, say Redmi phone or say Apple phone. Apple is a manufacturer. They are manufacturing a very prestigious phone. If they are manufacturing something and if we, being said a trader from India, if we import that Apple phone within the territory of India and sell it by changing the logo, by changing the name. Let's say we have given the name of say ABC company. In that case, what right is available with the Apple company? Can Apple company restrict us? No. You can't sell this product because this product has been manufactured by us. That's why you cannot sell this product under your name within your territory. The question is whether any kind of protection is there. So let me move to a very basic concept that why IPR right. I'll be answering to that question first in later stage. The question is why IPR has come into picture. Why IPR has been given so much of priority in these days. Basically, we all know that human central activity of human being depends upon three factors. The first one is called the creation, the second one is called the accumulation, and the third one is called the enjoyment. So once you are creating in one hand, we are creating something, we find very much satisfaction whenever our creativity is getting recognized in the entire world. So that is for creation. That's why creation is being given proper value. Number two is accumulation. Accumulation means what? Say, for example, if we find that we need to have a very luxurious kind of living, ma'am, in earlier slide only. Yeah. So we want to have a very luxurious kind of living. In that case, we want that every luxurious kind of living should be there in my home or in my, let's say, in my reach. So that is called accumulation. So if you think that yes, it's a very hot day, that's why I should have I should have an AC, I should have a say fan, I should have some other luxurious kind of thing so that I can feel very good in this hot temperature. So that is the concept of accumulation. And the third one is called enjoyment. So my sole purpose, the human being's sole purpose is to enjoy the living. So that's why human being, the activity depends mainly upon the three activities, three parts. That is called creation. The second one is called accumulation, and the third one is called enjoyment. Now the question is how you can enjoy your life in a very good way. We need to have a property. We need material kind of luxurious kind of things so that with those I can live my life in a better way. So that's why the concept of property comes into picture. So how you can have the property? We can have the property by having say good source of money or good amount of money. Basically, four objectives of human life is are number one is called artha. Refer to the ancient texts. It says artha, kama, dharma, and moksha. Artha means money. So if you have money, we can buy property, and with those property, we can have a luxurious life. So that's why I have tried to define property in this slide. Then we can classify property into basically into two categories. The first one is called real property, and the second one is called property of property means on those properties that you control. Let's say you are buying a fan, you are buying a refrigerator, you are buying an AC, air conditioner. So these are all your real properties because you are buying with your own money. And certain properties we are getting, and those properties on those properties we cannot claim being as our own. So that's called property of the common. Say, for example, we are sharing the environment with the other persons who are also living, with the other animals also, they are also living. So that's like environmental resources or say roads. These are the properties of the common. So we'll be focusing on the property, but to some extent we'll also be touching upon the property of the common. Now the question is why property is very much important. The top reason is very simple, is that if you are inventing something from your mind, from your intellect, first get recognition. Once you will be getting recognition, then only can have a very life program. But I now define it as before and after.
Excuse me, sir.
Yeah, yeah.
Excuse me, sir. Sorry for interrupting, sir. So your voice is breaking, sir. Can you please change the locations and try
Okay,
it
okay,
out,
okay,
sir?
fine. Give me 1 minute time. I'll be switching to my other network.
Yes,
Okay.
sir, sir. No issues, sir. No issues.
Okay. Am I audible now, ma'am?
Yes, sir, you're audible now, sir.
Okay. Thank you so much. Yeah. I'm extremely sorry for this network issue.
No issues, sir.
Uh, so I was explaining about that what are the central activity of human being. Basically, we can classify central activity into three categories. I'm simply summarizing whatever just now I've explained. It's about creation. The second one is called accumulation, and the third one is called enjoyment. So if you're creating something in one hand, whatever with those you can have a better life, number one. Number two is if you find that other person is also developing something or has developed something which is beneficial for you, you will go for accumulating that thing. That's called accumulation. And the third purpose of human life, that is called enjoyment. So your sole purpose is that you should have a very good life, so that you can have a better life, you can enjoy your life in a proper sense. So, what are the basically four objectives of human life? I'm saying about four objectives. The first one is called Artha. You can refer to the ancient texts. The first one is called Artha. Second one is called Kama. Third one is called Dharma. And fourth one is called Moksha. So, why I'm saying this? The first one is very important in the sense of IPR. That's called Artha. Artha means money. So, if you have a good amount of money, if you can afford luxurious living or luxurious life or satisfaction of life, you can buy those properties. With those properties, you can have a very good living. So that's why money is needed. So money supports property, right? So property can be classified broadly into two categories. The first one is called real property, and the other one is called property of the common. So if you are referring about real property means the property which is yours own, or you can claim something, claim some right over it, by excluding all other members of the society from that property. Say, for example, landed property, real estate, fan, AC, refrigerator, chairs, tables, etc. Everything, these are all your real properties. Second one is called property of the common. So what is the meaning of property of the common? Say, for example, if you wish to travel from, say, West Bengal to, say, Delhi by road, so who owns that road? It's the entire community, or all the persons, or all the residents of India. They are the owner of this property. So that's property. That road is the property of the common. Or say in these days, just in the day of Diwali, we have realized that the pollution level has increased dramatically, right? From pollution level has increased. Now, who are the sufferer? Because of the act of few persons, many persons are getting suffered, are getting being suffered. So, if whether the persons, the sufferers, can sue against the government, that government does not have proper policy in restricting, in monitoring these kind of activities, right? So that's why environment is a property of the common. So that way, broadly, we can classify properties into two categories, real, and the other one is called property of the common. Now the question is, whenever you are referring about real property includes intellectual property rights, IPR, where we will be focusing on. So I for intellectual, P for property, and R for rights. Ma'am, next slide, please. Yeah, thank you, ma'am. Yeah. So when you are referring about the property, we can classify property broadly into two categories. The first one is called tangible property, and the other one is called intangible property. Property tangible. Tangible means the property which can be seen, which can be touched. Any property which can be seen, which can be touched, that these are tangible property. The other properties are known as intangible property. Intangible property means what? Anything which comes from your mind, or anything, or let's say you have a shop as a fast food counter, and you have a very good goodwill. People trust you that you use a very good quantity, very good of quality of food in manufacturing, or in producing, or in cooking your items, your food products. So that's why you are carrying a very good goodwill. So if you are having a goodwill, that is called your intellectual property, and that is called your intangible property, because that cannot be seen, that cannot be touched, but that can be felt. So if any property which can be felt but cannot be seen, but cannot be touched, can be known as an intangible property, right? Intangible asset. So if you're referring about intellectual property falls within this category of intangible property. So, so that means what? It includes, say, patents, it includes, say, copyrights, it includes, say, trademarks, it includes, say, designs, it includes, say, geographical indications, or say it includes, say, the that's called trade secrets, etc., etc. So that we can, or say plant diversity, plant biodiversity. So that we can cover many aspects within the purview of intellectual property, because these concept of intellectual property is gradually developing. So we can refer about one particular instance of 1474, where for the first time patent was granted. I'll be explaining what is patent in my next slide. So what is in the year of 1474, the 15th century, for the first time, patent was been granted for what? For manufacturing glass. So Venetian law has for the first time granted patent to one person in the year 1474 for manufacturing glass. So that was glass. Of course, that requires some kind of technique, that kind of technology, that kind of additional mindset, educational innovation. So if this is there, that way you can develop something on a new kind of concept can be developed. So if you are able to develop something anew, it may get protection in the name of patent. I'll be explaining what is patent. Madam, next slide, please. See, what are the broad areas of intellectual property? Just now I had explained. The first one is called patents. Patent basically protects your right in the name of innovation. So if you're innovating something, say for example, the person who has innovated pen for the first time, say, or say mobile phone for the first time. Say 20 years back also, we didn't think of that, yes, we could talk to one person by sitting in my place and he will be sitting in a different place. So, but that thing has got proven whenever one mobile phone was established. So the person who has manufactured or who has invented this kind of idea that yes, by sitting in one place without being connected through a wire to the other person, you can simply talk or you can simply see him or directly interact with him. So the person who has invented this kind of concept, he requires some kind of protection, because why he will be interested to share his view to the common public. So that's why the Patent Act 1970 has come into picture. So Patent Act of 1970 protects the idea of product. If you're manufacturing a product, let's say 2 years back, one particular company, Serum Institute, has invented one particular vaccine which works against corona disease. So if all of a sudden, if you are inventing one particular vaccine which works against, say, a particular disease, COVID disease, that means you require or your claim for protection must be recognized. So how, until and unless any law is there, your protection, you will not get any protection. That's why Government of India has realized that we need to have one law, and that accordingly in the year 1970, Patent Act has been passed. Moving to the second category, that is known as Copyright Act. Copyright Act of 1957. So what purpose Copyright Act 1957 serves? Basically, say, if you are writing something, say you have written a poetry, or say written a novel. So all of a sudden, if I copy it and circulate it in my own name, that is, this is my creation, so definitely your idea, your thought, your intellect will be affected, right? So if literary work of yours requires protection, and if you believe that this is your work and that should be protected, that should be recognized, that's why Government of India has realized, and Government of India has passed a particular law in the name of Copyright Act of 1957. Number two. The third category is known as trademarks. Let's say if you are buying, say, Tata, say, four-wheeler. If you're buying a Tata four-wheeler, you'll find that one logo is there, T kind of logo is there, and that has been encircled by one circle. So T is there. So once you'll see that logo, T for trust, we believe that since that product has been manufactured by Tata, we can trust that this product is of good quality or will give us the best satisfaction, right? So company company provides or makes available the product into the market with certain logos, so that you can repose your trust, or you can believe, or you can think that yes, this particular product can be trusted because that has been manufactured by Tata, and they are carrying a very good say reputation for last say 200 years. So how come Tata will be communicating the message this particular product has been manufactured by Tata only? Say for example, if you are referring about four wheelers vehicle, these are you will find many vehicle producers are there in the market. Say for example Maruti, say for example Innova, Toyota, say for example say Mahindra, say Tata, say Ford, etc., etc. So many producers are also there. But how come we'll be knowing that this product is being manufactured by Tata and we will be getting the best satisfaction? Because Tata will be using their trademark over it. Trademark. So that's why if you're putting a trademark in a particular design, a particular shape, it requires protection, and that's why law has been passed in the year 1999 in the name of Trademark Act 1999. We have another law that is known as Designs Act of 2000. Designs Act simply says that if you are making a particular design which attracts, which appeals to your eye, by looking at it, you can easily say that yes, this is a very good design. And who has invented the design? Say Mr. A. Mr. A has invented that design, or say A company has invented that design or has developed that design. So until and unless A's name, A company's name, or Mr. A's name has been there in that product, you will not be understanding that who is actually manufacturing it. If you are manufacturing or if you are making a design, you must get a protection, and that protection is been ensured with this Act of Designs Act of 2000. We have another law that is called GI Act of 1999, Geographical Indication of 1999. It says if any product belongs to a particular territory, say for example Darjeeling tea. Darjeeling tea is been produced, that particular tea with a particular fragrance is produced in say Darjeeling in the West Bengal. So if say in Africa, if you're manufacturing or if you're producing a tea, planting a tea, and you are putting that tea into the market or selling that tea into the market in the name of Darjeeling tea, definitely you will be sued. How come? Because that law is there. GI Act, Geographical Indication Act 1999, clearly says that if any product has got a relevance, has got some attachment, has got some connectivity with a particular geographical area, definitely that product must be tagged with that geographical area. And if you're producing similar kind of product in different parts, you cannot use that brand name. Say Darjeeling tea, say Assam tea, that cannot be used. And the last one is trade secrets. Trade secret means if you are manufacturing something, inventing something, producing something, and if you have a tendency or if you have a thought that is I'll not be sharing that secrets with the common public, you still will have the protection from the eyes of law in the law. So let me put you one question to everybody. I hope you all have heard about Rasgulla, right? Rasgulla. Uh, 2 or 3 years back, Rasgulla case was being heard by Supreme Court of India. Can you please tell me that between which states that case was being fought, or what was the actual dispute regarding the Rasgulla case? Who can answer? Any one of you? I want this session a bit interactive. So if you have any kind of thing, no, anything is there in your mind, you can simply ask me. Yeah. Am I audible to everyone?
Yes, sir.
Yeah. So just now I have asked that, have you heard about the case of Rasgulla? In Bengal, that's called a very famous sweetener, sweet. Rasgulla. Odisha, exactly. Yeah, Santosh Mehra, very good. Odisha and West Bengal. So who has actually won that particular case? Santosh, are you aware? In whose favor the judgment has been given? Yeah. Anyone of you?
Hello?
Yeah. Yeah, Santosh.
No, no, sir. Actually, I don't have that clear idea, sir, regarding this. But I have heard that news over the television regarding Odisha and West Bengal. That is the issue.
Right, right. So between Odisha and West Bengal, that case was filed, has been fought. Odisha claimed that we should have the patent in the name of Roshogolla, or geographical indication in the name of Roshogolla. And Rasgulla has been claimed by West Bengal that no. This Rasgulla, Nabin Chandra Das in 18th century has invented that particular sweet in West Bengal. And that is very famous in West Bengal. So that's why we should have that term. We should have that right to use that term. So finally, Supreme Court of India has given judgment in favor of West Bengal, saying that the Odisha's Rasgulla is something different because their preparation is something different. That is not that soft like that of a West Bengal. So that's why that way Supreme Court has pronounced their judgment. Well, have you heard about Basmati case? Well, for your knowledge, I'm saying that Rasgulla case was been disposed of in the year 2019. In 2019, that judgment was been pronounced by Supreme Court of India. Well, so have you heard about Basmati case? Basmati rice case? Any one of you? Basmati rice. Okay, no problem. Basmati case is basically a production of certain rice, particular with certain fragrance, certain say, I mean, what I can say, a particular variety of rice has been produced within the territory of India, and that has been sold in the name of Basmati rice. So few years back, USA has made patent and accordingly started selling some rice with the name of Basmati. And government of India has objected to it that no, Basmati rice is a brand name being used within the territory of India for a particular variety of rice. Yeah, exactly, Rajesh Verma. Yeah, thank you. Basmati produced in Dehradun, Uttarakhand. Right. So within the territory of India, if we are producing certain rice, we are selling that particular variety of rice in the name of Basmati, that cannot be used by USA. Because people will get confused. Let's say if you have got the taste of Basmati rice, and if you, by staying within the territory of India, and after say a few years, if you move to say USA or say other parts of world, and if you place an order of having say Basmati rice, 1 kilo of Basmati rice, and you are being delivered with a different variety. In that case, do you have any right to say, no, I didn't ask for that particular variety? What I have asked for those rice which are produced, which are planted in say Uttarakhand or say Odisha or say West Bengal, etc., etc. So until and unless we have a clarity about the variety, that which variety should be named as a Basmati rice, our rights will be affected. So accordingly, Government of India has put its objection, and finally in 2001, judgment has been pronounced in favor of Government of India, asking USA government to rename the variety of their rice which are being sold in the name of Basmati. Finally, that judgment has been given in our favor. Right? Okay. So moving to our next slide without being dragging much time. Yeah. So what are the rules regarding patent? Just now I have explained that what is about patent. Patent means if you are innovating something, if you are producing something. So with your innovation, with your uniqueness, with your unique thought, if you are inventing something, that must get the recognition in the name of patent. So either you can go for patenting your product or you can patent the process. So both ways you can get the protection. So patent rights, as I have said, the patent right in the year of 1970, Patent Act has been passed in the year 1970, which clearly says that if you are inventing something which has got a novelty, so what is novelty? A new thing, a new kind of thing has been developed, which has not been thought previously by any other person. So novelty is there. Non-obviousness. What is non-obviousness? Non-obviousness means it cannot be generally expected that this thing would be the result. Say, for example, if you are mixing up two elements of hydrogen with one element of oxygen, it will definitely result into making water, H2O. Two elements of hydrogen with one element of oxygen, if you mix up, that will result into making water. So that is obvious. So whoever has invented, whoever has claimed, I'll not say what, I'll not use the word invention. I'll say that whoever has claimed that two elements of hydrogen with one element of oxygen can be mixed, and accordingly that will result into water, he is not eligible or entitled to get the patent. Why? Because it is quite obvious. Quite obvious. So if you wish to have patent right, patent recognition, you must claim something non-obvious thing. Number two. Number three is, if knowledge is there in the public domain, let's say how to make say momos, or how to make say samosas, everybody is aware of. If someone makes, if say Haldiram makes samosas, and Haldiram claims that since we are making samosas in that particular shape with that particular taste, so that's why we should get the patent. No, definitely no, because that knowledge is already available in the public domain. So if any knowledge is there in the public domain, you are not allowed to claim to get the patent rights. Number four is public use. If you are inventing something for yourself only, no patent will be given. If you have the sole intention to place this product for the betterment of the whole society, so if your sole intention is to benefit the whole society for public purpose, public use, then only you can claim patent protection, right? So patent protection, Patent Act of 1970 basically, if we are referring about Patent Act of 1970, it only gives you protection within the territory of India, not outside the territory of India. So just now I had mentioned that we can have patent on two things. The first one is called if you are manufacturing a product. Say for example, Serum Institute has invented one particular vaccine, has given the name of say Covishield, and Bharat Biotech has given the name of Covaxin. So the product they have manufactured, they can, if since these are the new product, that's why they are eligible to get the patent right. How they have manufactured? By mixing up say amoxicillin, say other chemical compounds within it. So these are the process. So the process can also be protected, or the product can also be protected. So patent right basically gives the monopoly right to whom? To the inventor. For making a product, for inventing a product, or say developing a process through which this product can be developed. And the monopoly right is, the duration of the monopoly right is only for 20 years. Why 20 years? Because till 20 years, government is duty bound to give you all kinds of protection. So if somebody is pirating or is developing or is fabricating the product or is developing another product in your name or by using your application, Government of India will put restriction on it, on that particular person. So that's why till the expiry of 20 years, you have sole freedom. You have the sole monopoly right to get the benefit from your invention. And next slide, please. So that is called copyright. Copyright Act of 1957. Copyright Act has been passed in the 1957. I had already explained that part. So what is the purpose of having copyright? Let's say if someone who is writing, say, I'm referring about, say, Jeremy Bentham. Jeremy Bentham, who is popularly known as the father of jurisprudence or father of the law, or say John Austin, father of the law. So if they are writing a book in the name of, say, limits of jurisprudence defined, they've explained that how law will function, how law will work, what are the responsibilities of state, etc., etc. So if you're there writing something, or say Karl Marx has written Communism, how, if we are copying it, or if we are photocopying that entire content, entire written thing, or say Rabindranath Tagore has written something, if we are photocopying it, if we are selling it in our own name, ignoring the name of the actual poet or actual writer, in that case, you will be violating the copyright law. So copyright law protects the literary work, dramatical work, musical work, artistical work, cinematographic film, etc., etc. Let's say a few days back, one movie was been made, Kashmir Files, right? Kashmir Files by one particular director. So if all of a sudden, if one of the, I'm not naming the director, if all of a sudden another person, another director claims that no, this is the novel written by me only, and he has simply copied it. He has simply copied it. In that way, the person who has copied, he will be liable for penalties. So what the penalties I'll be explaining in later part. So generally, your Copyright Act, copyright law will be giving you the recognition, will be giving you the protection for 60 years. 60 years from your death. Basically, the term of copyright is of 60 years. So from the death of the author, from that day onwards, 60 years time protection is there for the purpose of the copyright protection, right? Okay, ma'am, next slide, please. That is called trademark. Let's say, I hope you all have heard about the Tata vehicles, Tata four-wheelers. Uh, I'm not sure, but still, Tata, as far as I can remember, the Tata does not manufacture tires. They basically buy tires from, say, MRF company. Let's say, taking one hypothetical example. Say MRF company is supplying or is manufacturing or is producing, say, tires, and they are supplying to Tata company, Tata vehicles, so that they can assemble it, and accordingly a full complete shape of vehicle can be given. Now the question is, if MRF company is manufacturing tires, they are putting their logo on it. MRF, Madras Rubber Factory, MRF. If Tata finds that no, since we are selling the vehicle in our own name, because it will be known as Tata, say, Sumo, or say Tata Nexon, so that's why the name of the tire should also be changed from MRF to Tata, because Tata is buying from MRF company. So we cannot or will not be interested in marketing the product of MRF company. So if MRF company is putting their logo on tires of the Tata company, Tata vehicles, in that case, indirectly Tata company will be marketing the product of MRF company, right? So in that case, if Tata company decides that no, we'll be putting a label on MRF logo, and accordingly we'll be using the word Tata on it. Will it not be considered as a violation? What is your opinion? Any one of you? Any one of you can answer. Have you got my question?
Come again, sir.
Yeah. My question was, MRF company is manufacturing tires, and Tata company is importing or using the tires in their vehicles by giving it a final shape. Now, Tata company is not interested to mark to allow MRF company or to use the logo of MRF company in their own vehicles. And so Tata company has decided they will be putting a different label on the word MRF on the tires. So whether Tata company is permitted to do so? What is your opinion, Mansoor?
So maybe they are legally put some contract, right? Maybe for using some other parts. Maybe Tata is not manufacturing tires, so they are simply buying the best quality tires from any other concern, right?
Right, right. So you are saying that if
So
there is an arrangement between MRF company with Tata tires or the Tata company, in that case, that
yes, sir.
logo can be replaced, right?
Uh, in the vehicle, they are in Tata vehicle. They are mentioned there. Uh,
Hmm. Mansoor, your network issue is there. Mansoor, I think from your side some network issue is there. Anyways, any other person who wish to answer? Okay. Say my question was that whether Tata company is permitted to replace the logo used by MRF, because they are say buying the MRF tires and they are assembling it in their vehicles. The answer is generally no. Why? Because once you are not manufacturing a tire, manufacturing a part, and if there is no arrangement, just now Mansoor has also stated in that way only, if there is no arrangement, no agreement been made between Tata with the MRF tire to replace the or not to use the logo of MRF in that particular tire, in that case, they are not legally permitted. Now, how we can define what is trademark actually? So, trademark means any distinguishing mark on goods or services through which you can identify the goods or products or the services of that particular company. Let's say if you are buying say Ajmal say perfumes, these are very branded perfumes, right? So if you are buying Ajmal perfumes, you are not permitted to change it, right? Just hold it for a minute. দাদা আমি একটা ক্লাসে আছি, হ্যাঁ আমি একটু পরে ফোন করি। So you are not permitted to change it. Just now I've said that if one particular company is engaged into selling of some goods or providing some services in a particular brand name, that brand name recognizes or gives assurance to the common public, to the consumers, that they are assured of that best services. So that's why trademark is there, and trademark is permitted. So if somebody is violating the trademark, in that case, there is a penalty. So validity of trademark is of 10 years and it can also be renewed. Ma'am, next slide, please. That's called industrial design. So Industrial Design Act has been passed in the year 2000. In the year 2000, that law has been passed, industrial design. So basically, if you are manufacturing something which appeals to your eyes, by looking at it, you can simply identify that whether it's a good product or not, whether it has got some kind of aristocracy attached with the product or not. So that's why designers are being hired. So if a company gives a unique design to a product, that design requires protection and that design is valid. Or if you have gone for registration, then from that date of registration, your design is valid for 10 years. Initially for 10 years, you can go for renewal for another 5 years. So in total, you'll get protection from the eyes of law, from the government, for only 15 years. Initially for 10 years, after renewal for 5 years. So after 15 years, no more protection will be provided to the industrial design maker for that particular design. Let's say if someone is making say lehenga kind of thing, lehenga product with a particular word on it. So the idea, whatever has been done in developing or in producing that particular apparel, that particular say dress material, that requires or that if you wish that thing should be recognized, should get protection. Initially, you can claim the protection for 10 years. After that, after the expiry, if you go for renewal for 5 years, in total 15 years, after that, this will lapse. This will belong to the common public. So initially, I had said the property can be classified into two categories. The first one is your sole property. Sole property means till the period of 15 years, that property, that design belong to you. Whoever will be using that design, they need to pay you some revenue. So till 15 years, you can claim, you can charge some money. After 15 years, that design will be available to the whole public, right? Ma'am, next slide, please. That is called geographical indications. So what is basically geographical indication? I had already explained geographical indication by referring to say Darjeeling tea. Darjeeling tea means the teas with a particular fragrance being produced in Darjeeling area. West Bengal. So if say a person who stays at say Africa, if he also engages into that kind of practice of producing say teas, and he has also given the name of his service, name of his product as Darjeeling tea. So people who are buying Darjeeling tea, they might get product directly from, if that once been allowed, or if that goes, in that case, people might get, or consumer may get from say West Bengal. That means the original product, or sometimes they may get the duplicate product from Africa in the name of Darjeeling tea. So if you get unlucky in say getting the thing delivered to a doorstep from Africa, you'll not get that taste. You'll not get that fat. In that case, you will be cheated because you have paid more money in comparison to the other person, whoever are getting the real product. So if you are being cheated by delivering that product from say Africa with the name Darjeeling tea, Darjeeling tea, definitely your right will be affected, and you can claim, or you can say that the product should be immediately stopped. Delivery of the product from Africa should be immediately stopped, or they should be asked to rename their brand, not to use the term Darjeeling tea, because this indicates that this product Darjeeling tea indicates that this particular tea is being produced only in Darjeeling. So basically, it relates to a geographical area, and validity is of 10 years only, and that can be renewed. So I'm not saying that the term of renewal is limited for a certain period. No, that can go for a year, that can go for centuries after centuries. So like Rasgulla was invented by Nobin Chandra Das of West Bengal in 18th century. Still, that product is readily available in West Bengal. So if someone is buying Rasgulla from West Bengal, he will get one particular taste only. So people, if they are engaging into the practice of producing that particular sweet by staying at a different place, not in West Bengal, they cannot keep their product's name as Rasgulla, because that will be violating the conditions of geographical indication. Initially, if you're inventing something, if you're manufacturing something relating with the particular area, particular geographical boundary, that will get protection for 10 years. If you go for renewal, that renewal period may, or say you can go for renewal after renewal, initially for 1 year, 2 years, 10 years, etc. etc. So that thing will go on. Then next slide, please. Traditional knowledge. So what is basically traditional knowledge? If some knowledge is there with the indigenous community, like say if you move to Assam or say northeastern states, you'll find that they use very unique kind of ideas for their day-to-day living. So they have never bothered about registering their rights or protecting their rights in the name of patent, in the name of copyright, in the name of trademark, etc. They have never bothered about. So that's why in the name of traditional knowledge, they are getting the protection. Civil court is there. So if someone is violating, if they get the indigenous knowledge by visiting to say northeastern states, and they start manufacturing this kind of thing in their own name, they will not get patent, they will not get any kind of recognition, they will not get any kind of monopoly or advantage in the name of monopoly. Like say basmati rice, like say neem, like say turmeric case. I hope you all have heard about turmeric case. In the year 1997, finally a decision has been given in favor of government of India. Basically, turmeric case turmeric is a haldi, is regularly being used as an antiseptic kind of thing. So Japan government has allowed few companies to use turmeric product in that particular name, and to use the name, or to use the brand which are very similar like that of India. So that way they had violated the rights whatever are there within the traditional domain. Government of India has objected to it, and finally decision has been given in favor of Government of India that no, it only belongs to India because it can be deeply rooted. It can be found as being deeply rooted with the traditional knowledge, right? So that's when basmati rice, neem case, turmeric case, etc., has been pronounced. Then next slide, please. It's called trade secret or confidential information. Trade secret means what? Let's say, I hope every one of you have tasted Coca-Cola or say Pepsi. So every time you will be buying Coca-Cola bottle or say Pepsi bottle, you will be getting the similar taste, or say Sprite, you will be getting the similar taste. Now the question is, can you produce or manufacture or say develop a particular sophisticated drink with that particular taste, whatever taste the Coca-Cola company is bearing or is having? Answer is definitely no, because we are not aware that what kind of ingredients are being used in developing Coca-Cola products, right? So because these information are very confidential, so company has decided that if we go for patenting a right, that patent will be available with us for only 20 years. So after 20 years, we cannot have any kind of monopoly rights over it. But if we keep that information as being secret or keep it as a confidential information, then we can sustain in the market for say centuries after centuries. So they have decided that no, we'll not be going for patent right, will not be going for any kind of rights in the name of whatever rights in the name of IPR, but still they can get the protection in the name of trade secret. So competitors, if let's say if someone who has been engaged or who has been employed in Coca-Cola company, if he comes to know that what kind of ingredients are being used in developing that beverage, in developing that soft drink, and once he retires from that company, if he starts developing his own product with that particular taste by using those ingredients, in that case, Coca-Cola company has every right to restrict that person not to use those ingredients or not to share those information to the public domain so that their market can be affected. Sorry. So that is called trade secret. So accordingly, trade secret, we can have civil rights, we can claim civil rights in the name of trade secret. So I can refer about one particular case. In the last line, it is written Diljit Tita's case. Basically, Diljit Tita's case, in that particular case, what was happening, it is basically a Delhi-based lawyer case. One particular law firm has hired one advocate, one junior advocate. So the junior advocate used to make drafts, etc., 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 as a conditional service for that particular law firm. So when he retired, when he was terminated from his service, when his agreement got terminated, the junior lawyer claimed that whatever I had written, whatever draft I made during my association with the law firm should have my copyright, because I wrote those drafts. So that's why my copyright should be protected on those drafts. Finally, that matter has gone before Supreme Court. Supreme Court has decided to no, it's not about contract of service. Contract of service means day to day. If you are hiring someone on day to day basis, it's contract of service. Basically, it can be said as contract for service. Contract for service means people has been hired who has been assigned with some work. He has done whatever work he has done during his continuation of service. Those work will belong to whom? Belong to the company, belong to the employer. So finally, Supreme Court has favored the employer in the name of contract for service. Okay, so that's called trade secret or confidential information. So if someone gets the confidential information by getting engaged with a company, with some association, he is duty bound to keep it confidential even after his disassociation of service. Ma'am, next slide, please. Now the question is, what are the legal remedies available? Just now I had mentioned that you have all rights with you. You have all rights with you. But if someone violates, let's say we can witness, we can say on day-to-day basis that if you go to say Mukherjee Nagar, Delhi, you'll find that many photostat centers are being there. So if you go with one particular book, say the price of the book is say 5,000 rupees. You can make photocopy of that book by paying say 50 rupees or say 500 rupees. By paying only 50 rupees or 500, you can have the entire content of the book. Now the question is, if someone who has written that book with the intention that this book will be sold into the market, he will be getting the royalty. But all of a sudden, if one of the friends of you procures that book, and rest of the friends decide to make a photocopy. So that way, the royalty of the actual author will be affected. So what right is available with the actual author? These are known as civil remedies. What civil remedies are available in case of violation of IP rights? Number one is called injunction. So if someone is violating your rights continuously, you can restrain that person not to commit any more harm, any more pirated kind of thing. So you can restrain. So restrain someone, that is known as injunction. Court can pass this kind of order. Number two is known as ex parte orders. Ex parte order means if someone who has been called that no, see, you have violated my rights, please come to the court, answer, take your defense that whether you have done legally or wrongfully. I find that you have done wrongfully to justify your stand if you have done it rightfully. If it does not turn up, in that case, ex parte order can be passed. Ex parte order means one-sided. Opportunity has been given to the defendant by serving a notice that please come to the court on, say, 1st of December and take your stand. If he fails to come repeatedly before the court for 3 occasions, in that case, he will be completely debarred from further appearance before the court. That is called ex parte order. So without hearing him, judgment can be pronounced in favor of the plaintiff, in favor of the claimant. That's called ex parte order, one-sided order. Number three, third right available with you in the form of legal remedy, that is known as order for deliver up or surrender or seize and destroy. If, let's say, if one particular photostat center makes a photocopy of, say, one particular book with if he keeps a 50 number of copies, he has found that there is a huge craze among the student to make photocopy of that book. So to save his time, he has kept 50 number of copies in his custody. So whoever will be coming, he will be simply delivering the photocopied volume. So if court finds that information, court will direct the no, go immediately, seize those properties, immediately destroy it. So this right is also available with the author. The last one is called award for cost and damages. So if your activity has resulted into affecting the royalty of the actual inventor or actual author, in that case, whatever loss he has incurred, he can ask for repayment of those loss. He can ask you to reimburse those loss in the name of damages, in the name of cost from you directly. So these are the civil remedies. Ma'am, next slide, please. Yeah. Criminal remedies are also available for trademarks and copyrights. Section 63 clearly says that if you are violating the copyright, let's say you are making the photocopy of a particular book, in that case, you will be liable for imprisonment for minimum of 6 months duration, and that may extend to 3 years. So from 6 months to 3 years, imprisonment can be given. You may be monetarily penalized with rupees 50,000 in the name of fine, 50,000 minimum amount, which may be extended to rupees 2 lakh. Criminal remedy for violation of copyrights. The same thing is applicable for trademarks also. It says that if you are violating the trademark, let's say Tata company is putting their logo on the tires, MRF tires, while assembling it with their vehicles, so that MRF, the word MRF cannot be visible to the common consumers. Tata company will be liable, or the director will be liable for imprisonment for maximum of 3 years of imprisonment with fine, which may be between 50,000 rupees to 2 lakh rupees, right? So apart from this, from trademark or copyright, there is no basically criminal liability is been mentioned in any kind of IP laws. We can refer about patent law, where it has been written that if you are fabricating or falsificating the entries in the register, say for example, you are inventing something and you have given false information that nobody has previously manufactured this kind of thing, and you are the first one who is manufactured, that means fabricating document or providing false information. So if you are providing false information to the registrar of patent, in getting the patent right, you will also get liable for the purpose of criminal offense. Ma'am, next slide, please. Yeah. So one particular question may arise that since I have mentioned about all those laws, and all those laws has got a geographical boundary within the territory of India. So beyond the territory of India, these laws do not have any kind of application. So how come they are giving you the international protection? So for the purpose of international protection, we have different kind of conventions, different kind of organizations, like say WTO, World Trade Organization. We all know about the WTO, which was attacked by Bin Laden. WTO, WIPO, WIPO, World Intellectual Property Organization, get general agreements on trade, tariffs and trade. TRIPS agreement, say trade-related aspects of intellectual property rights of 1994. So many conventions, many policies, many international conventions has been done so that one particular issue of one particular nation can be recognized by the other members of international community. So that way, no, that's where international community goes hand to hand. In that way, only one particular nation is getting protected, is getting recognized by the act of another nation. Right? So I hope this is my last slide. Ma'am, next slide, please. Yeah, this was my last slide. But still, if you have any kind of doubt, if you have any kind of question, you may simply ask me. I'm happy to answer.
The session is open for discussion now. You can unmute and interact with the resource person, or you can post your questions in the chat box also. Thank you all. Thank you, sir.
Well, someone has asked me one question. Let me see. Yeah. Uh,
What kind
what
of
kind
plant
of
product?
plant product? What kind of plant product should be patentable? How can we conserve the traditional knowledge on the medicinal plant? Okay. What kind of plant product should be patentable? Yeah. The first one is, if you're referring about plant product, basically in these days, no, we are seeing about the biodiversity. Biodiversity means we are having genetically modified seeds. GNA technology with those genetic thing you are changing. If you're changing that particular genetic in that particular plant, and that way, if you're putting another genetic thing in that particular plant, so that there can be more production on it. So you, since that has gone through a laboratory process, that thing can be patented. This is the first answer of the first question. The second one is, how can we conserve the traditional knowledge on the medicinal plant? So it's not only about medicinal plant. If there is a traditional knowledge, if you can establish that fact that this traditional knowledge was existent or was in practice, or was been adopted or has been recognized previously, if you can refer about any of these things, if someone of, if anyone of the person, any of the member has obtained registration in the name of patent or whatever, his registration will be immediately withdrawn, immediately cancelled. So the condition of getting thing patented simply says that there must be an innovation, there must be a new kind of thing was not there, that knowledge was not there in the knowledge domain. If you're making something new, then only you will get the protection. So even not making something new, because earlier it was available into the public domain, like in the name of traditional knowledge. So that's why you will not get any kind of protection. Even if it is a medicinal plant, you will not get the protection. So medicinal plant means, let me be very clear, that if you are doing any kind of genetical diversity on that plant, you will get the protection. Otherwise, if this is a of spontaneous growth, then there will be no other protection will be available. I hope it is clear.
Any other queries? You can
Any
unmute and
more queries
interact.
there?
You can unmute and interact with sir, or you can post the questions in chat box also. Any questions?
Thank you so much. Thank you all the participants for being so interactive and for asking questions.
Any queries?
I hope there is no more question from any other participant. So thank you so much for giving me the platform to explain my views on IPR. I wish this two-day FDP get a grand success, and my special thanks to all the participants for making the session very interactive. And uh, also, I equally thank to all the organizers of this academy who has been, I mean, arranged this beautiful program where I was been invited and I had kept my view. So thank you everyone. Thank you, madam, for
Thank you,
the
sir. On
opportunity.
behalf of IoT Academy, we thank Dr. Bhupal Bhattacharya for the enlightening and enriching session. We thank you once again for the amazing presentation, sir. We thank you for enhancing our knowledge with the commendable presentation. Thank you very much for your efforts, sir. I
Thank you
thank
so much.
all the participants for joining the session today. Thank you, sir. Thank you very much for your efforts. It was an amazing session, sir. Thank you very much, sir. I thank all the participants for joining the session today. Kindly submit the feedback form using the link that has been posted in the chat box. Thank you all. Have a great day.